By introducing myself, my name is Nathan Lewin. I'm a lawyer in Washington, D.C., who has spent his life not in the rarefied atmosphere of international law and fine legal theories, but working really in a system of law that law schools know has behind it teeth, courts, actual enforcement of legal judgments. My credentials for being here today relate to those activities. As the chairman of the prior session said, the important thing is to go after the bad guys. Well, as a private lawyer, I guess I brought the first lawsuit against the Holy Land Foundation and financiers of terrorism in the United States. I have deliberately avoided trying to bring lawsuits that are simply based on some theoretical possibility. We brought a case against the Holy Land Foundation, ultimately have recovered a judgment, not money unfortunately, but a judgment of $156 million on behalf of the family of a young man who was killed in Beth El, murdered by Hamas terrorists. And I think we can take credit for having put the Holy Land Foundation out of business. When we brought the lawsuit in May of 2000, people told me, this is a crazy lawsuit. This is the leading Muslim charity in the United States. What are you doing? Well, we were in the process of an appeal that the Holy Land Foundation had brought from a district court judgment that allowed the case to go forward when September 11th came along. I went out to Chicago to argue the case. The court recognized it was an important issue as to whether you could recover under American law. I asked the United States to file briefs. The case was argued. It was difficult enough getting to Chicago on September 25th, 2001, I can assure you. And in December of that year, President Bush, with the Attorney General on one side and the Secretary of the Treasury on the other, announced that the assets of the Holy Land Foundation were being seized because it was a terrorist organization, which vindicated our having brought the lawsuit. That's one way you go after the bad guys. The other thing with regard to lawfare is you protect the good guys. And I have authored a brief in the Supreme Court of the United States. Too few people really understand that there's now a case in the Supreme Court of the United States that very much affects the subject of the conference today. It's the Samantar case involving the former Prime Minister of Somalia. And the question is whether as an individual he has immunity under the Foreign Sovereign Immunities Act from civil suits brought in the United States. And on behalf of the American Association of Jewish Lawyers and Jurists, the Union of Orthodox Jewish Congregations, and Agudath Israel, I drafted a brief which has been filed in that case for one point, to tell the Supreme Court, look, if you allow this case to proceed against the Prime Minister of Somalia, you're opening the door to dozens, hundreds of lawsuits, civil lawsuits brought in the United States against Israeli authorities on the ground that they would be sued under some theory of international law. So as I say, I'm here today trying to provide a little bit of a practical approach to the theoretical questions that Erwin Cutler has raised in his opening statement. We had a litany of yard sites of very important milestones in the development of international law, great proclamations about how important various declarations are, and these declarations have been turned and have been used against Israel. And the interesting thing is that almost the only countries that take those declarations seriously in any way are Israel and the United States. And we're here because the consequence of these legal principles that have been announced on a theoretical basis end up with lawfare, with Israeli government personnel and American government personnel being threatened with criminal prosecutions and lawsuits all over the world. My task here this morning is to introduce the speakers and maybe introduce the subject. The subject of this opening session is called Legal Efforts Aimed at Inhibiting the Right and Ability of Democracies to Defend Against Terrorism. And, you know, we learn and are amused a lot by the Academy Awards. I don't know how many of you spent interminable hours watching how the awards were given, but the film that won the Academy Award, The Hurt Locker, gave you a real picture of what war is like today. It's not fought by armies on a battlefield facing guns at each other or swords as in the old days, but in one of the opening scenes of that movie, the predecessor to the hero of the film is killed by a bomb that is set off by a civilian up on a rooftop nearby who presses his telephone and sets off the bomb. That's what war is today. And one of the questions, certainly I think, which this panel can and should talk about is whether the rules that were announced and purport to be applied to protecting civilians and others who are non-combatants in about 1900 and 1910 and 1920 and even 1940 are applicable in any way to what is going on today when civilians are part of the war machinery on one side of the battle. Now, as I said, time is short. There's one of the things I do is I argue in courts of appeals in the Supreme Court. And when you're arguing in the Supreme Court, there's a red light on the lectern, a white light and a red light. And when the red light goes on, the Chief Justice of the United States says, "Thank you, Mr. Lewin," and you sit down. No time, no extra time even to finish a sentence. The Chief Justice and the Deputy Chief Justice of Israel were in Washington a number of years ago. I asked them whether they had ever seen a session of the Supreme Court of the United States, and they said no. So I told them, look, they could come that week because the court was in session. Arranged the seats for them. They came in, listened to 2 hours worth of argument. It was absolutely marvelous. The lawyers were fantastic. The justices were at the top of their form. The cases were easy to understand. And as we walked out of the courtroom, I said to the two of them, Justice Shamgar and Justice Elan, how did you like that? And they said it was magnificent. And I said, what was it that impressed you the most? I thought they would say the chambers, the justices were so good, the lawyers were so excellent. Both of them immediately said, the red light. We loved the red light. In Israel, we can't get the lawyers to shut up. We say, okay, we've heard enough. They keep talking. Well, today, because of the exigencies of time, I will realize one of my very fondest dreams. I will play Chief Justice of the United States. And when 10 minutes are up for each of the speakers, I won't do what Ms. Goldstein says in her instructions, which is send them a handwritten note. I've been to too many of these panels where handwritten notes are sent to the speakers, and the speakers put them under the notes that they have for the next 25 minutes of their talk. I will say at the microphone, thank you very much. It's time for the next speaker. Our first speaker today is David Harris. Mr. Harris, I'm sorry. Mr. Harris is a lawyer from Canada who has been involved in criminal and national security issues. And he's the director of the International and Terrorist Intelligence Program. He's had 3 decades worth of experience in the field of international security and intelligence affairs, and he served in the Canadian Security Intelligence Service. Mr. Harris will address today the instances where countries have been wrongfully inhibited from prosecuting acts of terrorism as well as the chilling effect of lawfare on state action.